What happens when law, business, and life collide? Each week on Lead Counsel, your host Tom Tona will take a deep dive into topics related to the law, the business of law, and life. There will be insightful discussions with industry insiders, experts, and thought leaders making significant contributions and meaningful differences in their fields of expertise. Tom is the founder and managing attorney at TonaLaw. He has been a practicing attorney since 1994 and the leader of TonaLaw since it opened in 2001. The goal of this podcast is to provide you with free information on law and the business of law, and to give you actionable tools related to each of these areas. Now, here's Tom.
Hello. Welcome to the Lead Counsel Podcast. This is your host, Tom Tona. I'm here with the ever effervescent Juliet. Jules, what's going on?
Hello. Welcome back.
How are you?
I'm doing well. How are you today?
I'm good. So today's guest is exciting for me because I've been in front of mediators before, but we have a professional mediator, Jeff Kichaven. Jeff, am I saying your name right? Kichaven?
Perfectly. Thank you, Tom.
Awesome. Welcome to the Lead Counsel Podcast, Jeff. How are you?
I'm doing great today. I'm happy to be here. Thank you so much for inviting me.
Yeah, I'm excited to be here. And for years, I've been in front of mediators. I'm going on 30 years. And I always try to choose somebody who's got as much experience, if not more than I do. And I'm looking at your CV. So I just want to give a little breakdown of your background, and then we'll jump right into the interview. So Jeff is the principal mediator at Jeff Kichaven Commercial Mediation. He has a very significant LinkedIn presence. So if you're not following him, you should connect. And he's one of America's leading mediators. He's been ranked in chambers on the national list and Who's Who legal lists as a global elite thought leader in mediation. He's an honors graduate at Harvard Law School. Ooh, fancy, Jeff. Now I'm really impressed. Phi Beta Kappa graduate at University of California at Berkeley. You've been a full-time professional mediator for 28 years, and you've been cited in both the New York Times and Wall Street Journal. So you've got a CV that's very enviable, and I'm excited to have you on.
I'm excited to be here. Let's roll.
Let's roll. And before we roll, didn't you just get another significant award that you announced on LinkedIn, I think this morning?
Yes, Best Lawyers listed me as one of the outstanding mediation attorneys here in Los Angeles, and it's the 13th straight year for that ranking, and very happy to share that with everyone. Thank you for mentioning it.
Yeah, that's amazing. So give me a little bit of background, how you went from a private practicing attorney to a professional mediator.
Thanks for asking that, Tom. It's an interesting path. I did commercial litigation for the first 15 years of my practice. Securities cases, all kinds of financial cases. And I loved it, and then I found myself not loving it so much, and I was looking for something else to do. Around that time, the firm where I was practicing hit on a huge contingent fee, and every partner in the firm got several years' income all at once, more money than I had ever seen in one place at one time. So this gave me a certain latitude of thinking, shall we say, the ability to take a chance to get off the path of least resistance. And I was just in the right place at the right time for mediation. Mediation was far enough away from litigation that I felt I was doing something different. And at the same time, it was close enough to litigation that I felt I was not just throwing away all of the skills and abilities that I had developed over 15 years. So I've never looked back, and it's one of the best decisions I've ever made.
I love that story on several levels, right? So this big windfall comes in, and rather than a pie eating contest where you then win more pie, you decide to follow your purpose, and you really listen to your heart, right, with that. So I love that you made that decision of going straight into mediation. And what was your entry point for that? Did you say, look, I'm going to start drilling down, taking classes? Did you get a degree in it?
Many of those things, Tom. I took a bunch of mediation training. I I printed up business cards that said I was a mediator, and I started going to networking events, holding myself out as a mediator. As I learned about the field, I started writing articles and trying to get on panels at different continuing legal education presentations. I did a lot of free mediations through the court annexed panels here in Los Angeles County State Court and Central District of California Federal Court to get some experience under my belt, kind of giving out free samples, and eventually people started coming back with paying cases. It worked out very well for me.
Oh my God, I love that. I'm going to say this again because I have a demographic that's typically, so I've been practicing almost 30 years. I think we're probably right around the same length of practice, closing in on 30. And many of the demographic of this podcast is people that are 10 or 20 years behind on their journey, maybe even more. Let me repeat what you said because I loved it so much. You did it for free to cut your teeth, earn your bones, and make your name.
Right.
Love that.
And then, Tom, at a certain point, I had to drop off those panels because people were calling me up over and over again to work for them for free, and I just couldn't sustain that.
Right.
So I found that once I dropped off those free panels, people started calling me more frequently for paying work, and it worked out very well.
I absolutely love that story.
those panels, they have a place. There's a time to join those panels, and there's a time to leave.
Yeah, look, I think you were brilliant in what you said. You did it to get the experience and the knowledge on your dime, basically, because if it's free, somebody's paying for it, right? So it's you. But you're providing a valuable service to an over-inundated court system as it is, because they're not paying for those positions. But I think what you just said is brilliant, so I hope everybody was listening to that. How have you seen mediation change from when you first started to today?
Tom, I'm glad you've asked about the changes in mediation. Obviously, the biggest change in the last many years has been the transition to online mediation, starting in 2020 with the pandemic and the lockdowns. I think I had used Skype once or twice in my life. I had never used Zoom before 2020. And then all of a sudden, we're in this new world where the whole economy went online. When we started mediating online in 2020, people asked me how I liked mediating online. And my first thought was, well, compared to not working, I think it's fantastic.
Right.
So that was number one.
Right.
And now I find in some cases people want to go back to in-person mediation. Some people prefer to mediate online. There's a whole variety of circumstances that contribute to people's decisions whether to mediate online or in person. For example, sometimes we've got people all over the country. Sometimes we have people in foreign countries. And the time it takes to arrange a date when everybody can come to one central place, it may take so long that it just doesn't make sense. So that's the most obvious circumstance where an online mediation makes sense. For in-person mediations, there are some people who just don't engage well when they're at home. They're too comfortable, whatever it happens to be. And you need to get people into the office. You need to get them face to face, eyeball to eyeball, in order to make progress in the negotiation. And then for every positive, there's a negative. There are some people who will respond better in person, and there are some people who, because they are at home and more relaxed and under less pressure in a sense, they will do better in the negotiation in that environment. So every case is different. Every case has to be managed on its own. And it's a matter of collaboration between the mediator and the lawyers to determine what format is best, in person, online, or some hybrid between the two. I think that's been the most dramatic development in the last several years.
Yeah, and again, so we do litigation. We do strategically believe in mediation as long as it's a genuine desire by the counterpart. A lot of times the carriers, and I don't know if you do you do bodily injury as well?
I do some, yes.
Okay. A lot of times it's a disingenuous attempt to just get things moving in. There's an agenda, right? And one of the most brilliant business people that I know out of West Palm Beach, Florida, is a guy named Craig Goldenfarb, said something that was really poignant at a mastermind, which is stop approaching meetings and communications with human beings with an agenda versus just remaining open and curious. And I've kind of always approached mediations that way as well myself, or negotiations that way. So it's going to be interesting, and I'll delve into that with you a little bit more. But I think that I prefer a lot of the in-person stuff when it's higher stakes, because there's something that gets missed when you're looking through a camera. Even though I'm looking at people through a camera, there's something about that visual connection that I personally like.
I like it too, Tom. I like it too. You can't always get it. It's not right for every case. There are some cases where online is better, and some cases where a hybrid approach is better. It needs thought. It should be done thoughtfully, not reflexively. I think that's the real point. Here's a distinction to keep in mind. Mediation is a great place to make a deal. It's a lousy place to prove a point. If you want to prove a point, there are perfectly good courthouses and arbitration centers all around the country. God bless you, go use them. If you want to make a deal, mediation is the place. And I sometimes tell lawyers that I would like them to limit their comments, or I ask lawyers, please, to limit their comments to those things which they think will help move us in the direction of the deal. It's not the place to try to prove a point.
I love that. That's brilliant. That really is brilliant. Before we move on to the next topic, give me a key turning point in your career as a mediator, or one influential case that sticks out in your mind as like, man, this was a pivotal moment in my career as a mediator.
Key points, Tom, there are so many. Every individual case is a learning experience. Every individual day of mediation is the opportunity to improve and to have a turning point. I think back to the first case that anybody paid me to mediate. It was a partnership dispute. It was with a lawyer who had used my services for free on one of the court panels. He came back with a paying case. And I was just on cloud nine that somebody actually paid me to do a mediation. And it was one long day of mediation, and we got the case settled. And that feeling of happiness, of personal and professional satisfaction, the thought of, yes, I can actually make a living doing work that I love and work that actually helps people get past difficult situations and solve problems. That's a high point that lives on in my mind, and I think will live on in my mind for the rest of my career.
Yeah, that's awesome. And I think you provide a really valuable service. Again, I do think it boils down to, with a neutral like you, it's going to succeed if the intent is there by both sides, because clearly you have the intent of giving the sides what they want, which is closure. But if one side is lacking that intent, and then that's where you're going to see kind of a stone wall. So let me ask you a question about that.
Tom, let me comment on that.
Yeah.
That calls into question the whole idea of courts ordering people to mediate, because lawyers are familiar with mediation. They know what it is. By and large, lawyers are not confusing it with meditation anymore, like they did 28 years ago when I started. So if a court has to order you to mediate, it probably means that you've already thought about it and decided either that it's not the right case or it's not the right time in the case. So when people come to the mediation as a result of a court having ordered them, or a contract requiring them to be there, their hearts are not always in it to the same degree. And those cases are, in my experience, tougher to settle. I do get some non-starters, and when I get a non-starter, I ask the people, by the way, how did you happen to come to mediation at this time in the life of the case? Oh, well, it wasn't really our decision. The judge made us come, or we have this contract and we have to come. And those are the situations when their hearts are not in it. When people come voluntarily, when they pay a mediation fee, when they pay their lawyers, when they take the time out of their own days, sometimes to travel or to take time out to commit a block of time to be online, they have literally bought into the mediation process. And when people buy in literally to the mediation process, they are more committed to it, more devoted, and we're more likely to get good results.
Awesome. Yeah, I mean, that's sums it up. I mean, just right to the point is, and I like that you draw the distinction, because the whole mandatory really does limit good intent.
You see, Tom, I can see if a lawyer has a reluctant client, and the lawyer needs a beard to get into the mediation. I can see where judges might say to people, to lawyers, I want you to meet and confer about the advisability of mediation and report back to me in 14 days, 21 days, whatever it happens to be. That way, a lawyer who's trying to convince a client to get into mediation can say, look, the judge really wants us to mediate. We're not ordered to mediate, but the judge really wants us to. And that's a smooth way for a lawyer to get a reluctant client into a mediation. It's more subtle. It's different than sledgehammering or ordering people into mediation. And in my view, that would be a better way for courts to handle it.
So one of our managing attorneys here at the firm, she's actually in the process of studying mediations. She actually studies at Pepperdine, which I saw on your CV. You have taught there, or you are currently teaching there. But she had a question for you about how you developed your style of mediation.
The way one develops a style of mediation is by studying other mediators, learning, reading, doing all of those things, and then deciding that you cannot slavishly follow or try to imitate or copy anybody else. You have to be authentic to yourself. And that is one of the ways that mediators distinguish themselves, is by the strengths of their personalities. There's no one mediator who's right for every case. And one of the growing up points for me as a mediator is learning that. You can't be somebody else. You have to be yourself. And what that leads to is a teaching point for lawyers in the due diligence process. It's a good idea to call the mediator and talk to the mediator and get a taste of that mediator's personality, so that you, the lawyer, can make your own determination. Is this mediator going to be able to get on wavelength with my client? Is the mediator going to be able to get on wavelength with the other lawyers involved and their clients? Because no matter how famous or how many degrees or how many shiny universities a mediator attended, if a mediator does not have the personality for you and your client and the other participants in your case, then that mediator is not right. And it's perfectly okay to call mediators and have conversations with them. And some people say, oh my gosh, that's an ex parte communication. But what do you think happens on the whole mediation day? Much of the mediation day is consumed with ex parte communications, private caucusing. So it's really nothing to worry about. And we as mediators, when we talk to lawyers who are screening us, we know that the lawyers are trying to spin us a little bit. we're not naive, so our defenses are up. And we also know that before the mediation takes place, we will be having conversations. If you have a good mediator, the mediator will be having conversations with all of the lawyers to get the inside information, the rest of the story, the backstory, the personality issues. So there should not be any concern by any one lawyer about talking to a mediator as part of the due diligence and screening process, because the mediator will have conversations with the other lawyers as well to negate whatever biases or impact, influence may arise from that conversation.
Is it typical? First of all, I learned something new today as a practicing attorney of almost 30 years so in all the mediations I've ever done, I don't think I've ever picked up the phone to speak to the mediator ahead of time in the screening process. So with and I know you're familiar with JAMS because you used to work there, we will get a list of agreed upon neutrals from the other side. And then we will then select, but a lot of times they're neutrals we don't know. And that could become the first sticking point. So you're recommending, is that widely done where counsel calls mediators in a screening process?
Sophisticated, I think it's a hallmark of sophistication of the lawyers.
I love it. I love the idea. I really do.
And also, Tom, there's a risk when you ask other lawyers what they think of mediator X, because that other lawyer to whom you're speaking may have dealt with mediator X in one case. And so however the mediator acted in that case, came on strong, didn't come on strong, whatever it happens to be, psychologists call it attribution theory. That lawyer thinks that's how that mediator is in every circumstance.
Right.
And the truth is that mediators have some range of approaches to any particular mediation. Now, our range of approaches is broader than what any one lawyer may have observed and experienced in any one particular case. I should also mention that we mediators, we sometimes think we are the ultimate chameleons and we can adapt and we can be different this way, that way. Our range of approaches is probably somewhat narrower than we ourselves believe them to be, but also broader than what the typical lawyer thinks. And that's why you have to do your own due diligence.
I think that's brilliant. You just literally changed what my practice is going to look like going forward on the mediation front. Because we're fairly sophisticated on the litigation front, it never dawned on me to do that vetting process with a live in-person. Maybe how long do those screening calls usually last? A half an hour?
No, not even that.
And you're asking just a couple of questions, basically, about their style and how they want to see the proceed if they're chosen, that type of thing.
Have you ever handled a case like this? What sort of experience you have with the other firm or the other parties involved? What are your approaches? Do you like joint sessions? Do you not like joint sessions? Do you use mediators' proposals? Those are some of the questions that are commonly asked.
All right. So
and then it's just the vibe, Tom. You just get a vibe from somebody. Like this mediator, my opposing lawyer is going to hate this person. Or, this mediator is really going to get great rapport with this other participant. And that's the stuff that really makes a difference.
Right, because if you know both sides will have great rapport, it will drop a lot of the defenses down that the parties walk in with.
Yes.
Right. So if you feel comfortable with that, I can see why it would be effective. I do have a question. I'm going to go a little off script because I'm thinking about you. And I watched a fantastic movie, and you probably can finish the rest of this sentence. But in the movie Worth, Michael Keaton plays Feinberg, who gets to administer the trust for the trust funds for the 9/11 survivors, which I'm intimately familiar with those cases. I found it interesting that he had a professional mediation practice. Right. And then he got tapped by the government, and then he continues to get tapped by the government. What'd you think of the movie Worth?
To be honest, I haven't seen it.
Oh, really?
I've interviewed Ken Feinberg. I interviewed him on the New Possibilities Hour, the webinar that I do with Gene Lawler for the Will Work for Food project to raise funds for food banks. And Ken Feinberg was kind enough to come and be our guest a few months ago. And his work, I was a little surprised. He said that his work is primarily as a mediator of high-stakes corporate disputes.
Yes.
He's most famous for doing the claims administration, the 9/11 Fund, Agent Orange, Deepwater Horizon, all those sorts of things. But his bread and butter is commercial mediation.
I think what's awesome
cases.
about what you do, and this is just my personal opinion, is so sometimes because litigation a lot of times might be a zero-sum game, right? In order for somebody to win, somebody has to lose. In order for the client to get their result, the other client has to lose and not get their result. And I love what the professional mediator can actually bring to the table, where instead of a zero-sum game, it becomes a game of contribution. Every side contributes. Every side gets a little bit of what they want, not the whole pie. But you're adding something to the universe from a conceptual standpoint.
Amen. Yes.
Right? So
yes.
I love that. I love that. I can see why this is your purpose, right? And I've always been fascinated by it. I've always been fascinated by what professional mediators do.
Well, I'm glad we have this chance for me to answer some of your questions.
No, it's been awesome. It really has. So what I would love to hear from you, and I think I know what they are because I see them being deployed right now as we're speaking. Discuss the skills that you believe are crucial for a successful mediator and a successful mediation.
For a successful mediation, we want clients to be making clear, strong decisions in a calm, informed environment. If we can do that, if we can create that, then settlements are the natural byproduct. Because most people, if given a reasonable opportunity to put a difficult situation behind them, will do so. They'll give up something to get something. They'll pay a little more, they'll take a little less in order to get all the benefits of finality. They eliminate risk, they get their time back, they stop spending money, all of those benefits of finality. So that, to me, is the hallmark of a successful mediation. Even if a case doesn't settle, a mediation can still be successful if people feel that they are materially better off at the end of the day than they were when they started the mediation in the morning. And that may be the result of clarifying issues, prioritizing issues, gaining information from the other side, the ability to share information directly with the clients and principals on the other side in an unfiltered way. You can set the stage for what future discovery will be so that you can say, okay, we need these documents or this deposition, or we need to tee up a certain motion before the court, get some additional clarification, and then we can come back to mediation. We can get what's missing, and then we can take another run at settling the case. So just because a case doesn't settle that day does not mean that the mediation is not a success. Now, what is the job of the mediator? So everybody in the mediation has a job. The client has a job, the lawyer has a job, and the mediator has a job. The client's job is to pick among the available options and decide whether or not to settle the case on the terms that are available that day. The job of the lawyer is to negotiate and to develop those settlement terms to present to the client. Here's your best option. Client, you can pay this, you can take that, or if that's not good enough, we can proceed with litigation or proceed with litigation a little while longer. The mediator's job is to create the environment where the lawyer and the client can do their jobs. So what do? Well, among other things, we have to stay calm. People love to argue about the subject matter of lawsuits. In fact, they're very well practiced at it. It's probably all they've been doing with that subject matter for months or perhaps years. Mediators don't get anywhere by arguing with people. I don't care if your mediator is Abraham Lincoln or the prophet Elijah. No mediator has ever won an argument with a lawyer, particularly in the presence of a client, because clients understand that the lawyer is their fiduciary. The lawyer has the duty of undivided loyalty, the zealous advocate. And the mediator's duties are a little unclear, frankly, but what is clear is that they're not the same as the lawyer's duties. The mediator does not have a duty of undivided loyalty. The mediator works for both sides, gets paid by both sides, keeps secrets for both sides, all of that sort of thing. So the clients understand that the lawyer's the one, because the lawyer's the one with the duty of undivided loyalty, mediators really cannot win arguments. What we can do is we can make sure that the right communications are taking place. We can make sure that the right information is being exchanged. We can make sure that the right questions are being asked. And we do provide evaluative impact. Some people, Tom, talk about this distinction between facilitative and evaluative mediation. I don't believe that for a second. I think that every mediation has both facilitative and evaluative components to it. I can prove it to you. I can prove that every mediator is evaluative. Here's how I can do it. What does a completely non-evaluative process look like? In my studies, I have found only one example of a completely non-evaluative process, and that is Freudian psychoanalysis. We all have in mind this sort of a caricature, a cartoon image of the patient laying down on the sofa, pointed away from the psychoanalyst sitting in a chair, having turned away from the patient, and not saying anything. And the reason that Freud developed this model for psychoanalysis is because Freud did not want his reactions to impact what the patient was saying. In other words, Freud wanted to be completely non-evaluative. And Freud understood that the evaluations come through with things as subtle as the movement of an eyebrow or a facial expression or whatever tell you happen to have. Now, there is no such thing as strict Freudian mediation. Nobody mediates that way, where they don't look at each other and face away. So every mediator is evaluating whether they want to admit it or not. Mediators can't get ahead of their skis. Mediators cannot say who's going to win and who's going to lose any more than a lawyer can guarantee a defeat or a victory in a particular case. But what I will tell people, if I think it's appropriate, is that while I'm not a fortune teller, I'm a pretty good odds maker. And I think the odds are either for you or against you. Sometimes the long shot comes in. I don't know. It depends on the client's attitude toward risk-taking. Many things factor into client decisions. To get back to it, the mediator must use all the tools, facilitative, evaluative, transformative, whatever it happens to be, to make sure that the lawyer can do the best job possible of advising the client, and the client can do the best job possible of acting on the lawyer's advice.
And making a decision.
Making the best decision. Yes.
Yeah, I think that I was very quiet as you were talking because I'm thinking about all the scenarios I've ever been in mediation rooms on high stakes stuff. And I think that, I mean, man, you got a lot of wisdom. Holy cow. Like what you're saying makes so much sense. So I think that a scenario I would give you, right? So what do you do in a scenario where you've got one side saying we'd like to mediate it, and you mentioned before it's got to be the right case. It's also got to be the right time, right? So
yep.
Is there, for me anyway, my take is that too early in the case is not the right time. You need to get to a certain point where there's enough information that's been exchanged that people say, okay, I have enough that I could at least preliminarily start having meaningful conversations. Would you agree with that?
Yes. The timing, it's different for different people, Tom. Think of it, compare it to a 7-card hand of poker. Nobody plays through, or only the worst amateur plays through all 7 cards, right? The better players can tell after fewer cards whether they've got a winning or losing hand, how much confidence they have in that hand, how much they want to bet, whether they want to play it all the way through. So similarly in litigation, different people will have different psychological and emotional needs for information. Some people will want more, some people will want less. There's some threshold that everybody has. Everybody has their own idea of some basic factual information on the basis of which they want to evaluate the situation. In addition to that, though, there's a critical psychological factor that goes into it. And that is, when are people ready to put the difficult situation behind them? And you can think of it in terms of Elizabeth Kubler-Ross's landmark work on death and dying and grieving for loss, denial, anger, acceptance, that sort of thing. Well, people cycle through those emotional states at their own pace and in their own sweet time. Some people more quickly, some people more slowly. So the ideal time to mediate, I think, is when a client they're through with denial, and the anger stage looks to the lawyer like it's beginning to wane. And it looks like the client is about ready to get to acceptance, but they're not quite there. And they need the help of some other professional to get their client there. When their client gets to the point where time is dragging on, the result is not coming so fast, or the evidence may not be coming in as beautifully as they thought it would, but still the client is kind of clinging to the idea that they can completely defense the case or they can break the bank on the case. And you as the lawyer know that neither of those is likely to happen. So many lawyers have told me they try to give their client advice in the privacy of the office. It's a tough case. We've got some challenges. The judge is not exactly going our way. The evidence is not coming in exactly as we thought. The documents have kind of surprised us. Maybe we should think twice about our strategy here. And then clients turn to their lawyers and say, Tom, I know it's a tough case. I know it's full of challenges. I know we have some uphill battles here. That's why I hired you.
Right.
And that's a tough conversation to continue. When you're in a mediation, though, and we're talking about these things, the mediator, the stranger to the situation, can say, I think your lawyer's right. I think that there are some risks here. I think your lawyer has properly evaluated that. And I think your lawyer's giving you good advice to consider these settlement options, perhaps options you haven't considered before or you've not considered seriously before. Maybe you should take those to heart. So a lot of the value that mediators bring, Tom, is to help good lawyers break bad news to their own clients. Every lawyer, the greatest lawyers, every lawyer has clients with unrealistic expectations. And you're doing the client a favor. You're doing a high level of service to the client by bringing that client to a mediation to prevent a situation where inappropriate risk is being taken. Yes, of course, we have to respect every client's right to take risks. At the same time, we have to make sure that the client understands fully just what those risks are.
Okay. Listen, again, I'm learning a lot from you during this podcast. I have another question for you, and I'm going off script a little bit. As a practicing lawyer, what advice would you give to lawyers when they're trying to flesh out a sincere intention to mediate against the corporate Goliath versus the nonsensical BS attempts. And I can give you several real world examples. I'm sure you have dozens and hundreds of these. But a buddy of mine was working on a paraplegic case against a very large Fortune 100 company. All along, they're saying there's $26 million in coverage. And they went to 3 different mediations. So as a plaintiff's attorney, my question would be, what advice do you have for plaintiff's attorneys to flesh out when it's a sincere request for mediation versus we're going to spend 8 to 16 hours or more of time for a complete waste of time and resources, and they just want it on a fishing expedition? We walk in and they offer $3 million on a paraplegic case that the verdict came in at $107 million.
Sussing out sincerity can sometimes be a challenge. As we were discussing earlier in this conversation, Tom, part of it is your counterparty willing to buy into the process? Are they willing to pay their half of the mediation fee? Are they willing to travel to get the right people to the mediation? Are they bringing the right people? Who is the right person who can make a decision if persuaded that the kind of settlement for which you're looking is appropriate? Are they bringing the right people? Are they committing the right amount of time to it? You don't want to get into a situation, and you can try to determine this in advance. We've all been in situations where at 3 o'clock in the afternoon, somebody says, "Oh, thank you very much. I have a flight at 5. I'm leaving now." And you want to get a commitment from people that they're there for the duration. All of these indicia of buying into the process, committing to the process, paying the money, paying their lawyers, getting the right people there, those are all very important indicia. And at the same time, Tom, the plaintiff should be contributing to the mediation fee as well, by and large, because you want the plaintiff to understand that the mediator is working for your side too. The mediator is not just working for the defense side. And sometimes it's difficult to decide to pay a cost which perhaps you could avoid if you asked the defendant to pay the whole fee. But then there's less of an incentive for the plaintiff to take seriously what the mediator says.
Yeah, you got to have buy-in. You got to have buy-in.
You got to have the buy-in on both sides.
No, I agree. Listen, I think you gave me a quick checklist. I'm taking notes as I'm writing because, it's podcasts like this that I love. There's so many practical takeaways. So let me ask you a question that has been on the top of mind for me because I've been attending masterminds and conferences, and all they're talking about, and I'm sure you know what I'm probably going to say, but artificial intelligence. It has become a mainstay for so many in their law practices, and there are smart uses of it. What are you thinking about the future of mediation and the impact of AI, using like ChatGPT 4 or other artificial intelligence models out there? What do you think is going to happen as far as the space of mediation?
I wish I knew what the future would hold, Tom. Compare it to psychotherapy. There are AI programs and bots which purport to be able to conduct psychotherapy. And you can get your therapy from a computer, some would say, from software. Well, I've never tried it, and maybe it helps some people. So I assume that people will be developing AI programs which can function as mediators, and maybe they'll work and maybe they won't. My thought, my hope, is that there's always a need for the human touch. What you were talking about earlier, something special happens when you're actually sitting in the same room with another human being having that conversation. Now, people might use AI to do better research in terms of how cases of this type may or may not be likely to come out in your court or your part of the country, whatever it happens to be. I think we're at least a long way away from AI actually performing the services of the mediator.
Yeah, I'm just so curious because I'm fascinated by the space, and it's evolving so fast that I think, people will just be, I think if people are smart as it evolves, they're going to incorporate it as a tool. And then there's going to be people that stick their head in the sand, and then they'll either go into retirement or they'll pivot, career wise, because I think there's a place for it. I was listening to a podcast, a friend of mine hosts, where they had a judge on, and the judge is basically saying how it could impact the judicial space, right? Like, he's like, look, I use it now in the authoring of decisions. I'm writing the decision, but I'm using the prompts to get the language models to concisely draw on information. So I find it fascinating. I don't know that it'll replace judges and mediators, but it might replace clerks. It might replace, the people that are typing up your decisions when you could just dictate into a website if you're typing up, formal decisions or anything like that. So I just find it fascinating. So I have to ask that. I'm starting to ask that more and more on these podcasts.
Well, how are you using AI?
So interestingly enough, I used it for the framework of this podcast.
We use it a lot, and especially in the marketing section as well. And I know our HR manager uses it a lot as well.
Our HR manager, Our HR manager. So we use it in marketing. So Juliet has a paid subscription to ChatGPT-4, and our HR manager uses it. I keep saying, I don't understand how you're writing all these brilliant ads. We hire 4 key people in 30 days. She's like, I've been using ChatGPT for, the last 30 days. So what we do is we input everything. That what it does is it spits out the ad in a way that resonates with people, right?
Because you can really get specific and tell it what you want to come out of it. So I think in some areas there is a use for it, but like Jeff said, I think in mediation, I think people could use it as a tool, but I don't see it ever replacing.
Right, but
anybody.
As a tool, it's brilliant, right? Like if I know I'm going in front of you, Jeff, I might say, and again, I'm very cautious about you don't put in client information, nothing with medical records into ChatGPT. Everybody's got to use it responsibly. But say, create a mediator statement that's 3 to 5 pages long that summarizes the following personal injury case. Here are the injuries. Here's the liability picture. And 30 seconds later, I'm going to have a draft that I can then work off of to then put my touch, my personality, my flair into it. But so those are just a handful of uses that literally, I'll give you another instance. We just used it really quick. I have a senior trial position open, and I had a lawyer coming in for a 2-hour interview, and rather than use the old 30-page script of interview questions and I jumped all around, I put it into ChatGPT-4 just to give me a framework for an hour-and-a-half interview, leaving a half an hour for questions. And I put in the job description, and what it wrote was way more brilliant than what I would have been able to put together myself.
Fantastic.
It was unbelievable. So these practical uses where it provides for tremendous leverage, right? For somebody like Juliet, myself, or my HR administrator, Alicia, they could do the work of 3, 4, 5, 6 people because 30 seconds after they input the prompts, if they did it the right way, it's giving them what they want.
That's fantastic.
So it's crazy. It creates this crazy leverage point. Jeff, you've been awesome. I want to thank you for coming on. How can people find you? Because I know you have a strong LinkedIn presence. I follow you. Let's spell it. Jules, you'll put Jeff's LinkedIn information in the show notes?
Yep. I'll put all of your information.
Perfect.
Thank you. And I welcome those LinkedIn connection requests. If somebody does wish to connect with me on LinkedIn, please just say, hey, heard you on Tom Tona's podcast, so that I know it's a legitimate person reaching out to me. My cell phone number, please keep in mind, I live in the Pacific time zone. I live in Los Angeles, California. So I handle mediations all over the country and really with participants all over the world now. But people are welcome to call me on my cell phone. The scheduling number is area toll-free 888-425-2787. 2520. And my email is my initials, jk@jeffkichaven.com.
Awesome.
And I look forward, Tom, to making many new connections and expanding my universe as a result of this podcast. Thank you very much.
You've given me a lot to chew on. Thank you so much for coming on. And anytime you want to come on as a guest, if you got an interesting case you want to talk about down the road that you're like, oh, Tom might like to hear this. And again, you kind of know what we do on the podcast. I would love to have you on. It was great meeting you, Jeff. And thank you so much.
And let me thank you, Tom and Juliet. The pleasure is all mine. It's wonderful to have an opportunity to explain this to an audience that cares about it, that will take it to heart and put it into use.
Yeah.
We're all here to raise the standards of practice. Thank you for this opportunity.
Yeah, thank you. And I think you do that. I think you do that with what you're bringing to the table. No pun intended. What you're bringing to the table is pretty impressive and special. Right.
Yes.
You're going against that zero-sum game mentality, which is kind of the reason that, like, in our office, I have a dedicated negotiator who's a non-attorney. He's always working on the attorneys. There's always an attorney in the room, but the attorneys think differently. His job is to be the voice of reason, the mind of reason, and not the adversary that the attorneys are. So,
sounds good.
Thank you so much, Jeff, for all of your wisdom and time.
Thank you for all of your wisdom and time as well. It's a pleasure to be here.